It's often been said that the practice of law would be great, except for the clients. Now, if this is your theory of practicing law, then probably CJA panel practice is not for you. In order to have an effective CJA panel practice, you need to effectively communicate with your client. Here at the Federal Public Defender's Office, with regards to appellate work, we take several steps in order to ensure that we have effective communication. The first of these might seem to be a quite obvious one, but it's an important one, and that is know where your client is. Many times when you pick up a CJA case, the defendant will be incarcerated with the Bureau of Prisons. In that case, it's very easy to find out where the client is because you can go to www.bop.gov and then punch in either their name, or if you have their U.S. Marshal number, you can put that in, and it will give you their current location. If not, if they're out on bond and you don't know their current location, then you can always call the U.S. Marshal's office and obtain their current address in that fashion. Now, once you have their address, the next thing that you should do is provide them with an initial letter. And this initial letter should not only introduce you to them, but also provide a brief outline of the appellate process and what steps are going to take place. Obviously, one of the first parts of the appellate practice is to collate all of the documents with regards to the case, obtain them from former counsel, and order a copy of the transcripts. Good, effective communication with your client would also involve you providing copies of those documents directly to the client. Remember, your client was at the trial or the plea proceeding and you likely were not. Therefore, they could provide you valuable information that you might not otherwise know by their reading of the transcripts. Another avenue of effective communication, and this seems to be a straightforward one, but it's one that a lot of attorneys don't follow, is to provide them with a copy of the draft of the brief prior to your filing of it. Now, a lot of times you cannot provide them with a draft of the brief much before the due date, but to the extent that you can provide them with a draft, it provides them with information on what you're going to argue and may give them the ability to communicate back and forth with you as to the issues that you're going to be raising on appeal. Once you file the appellate brief, I would provide them with a copy of that as well. And when the government files their brief, please provide them with a copy of that as well as soon as you can. Finally, when the court provides you with an oral argument notification, it's a great idea to provide them with a letter outlining the date of the oral argument and inviting the fact that their friends or family can come and view the oral argument if they so wish. Finally, and this again may seem a little straightforward, but effective communication is also the fact that you need to effectively communicate the opinion from the Sixth Circuit Court of Appeals. As soon as you get that opinion, you should copy it and provide a copy to your client. And this is especially important because your client has several options that are available to him or her by the time that decision is filed. There can be a petition for rehearing en banc, which can be filed with the Sixth Circuit Court of Appeals, or a petition to the United States Supreme Court. In addition, they have the right to file in the district court a petition pursuant to 28 U.S.C. Section 2255. A letter outlining all of these options to the client is important for effective communication. And please keep in mind that pursuant to Sixth Circuit local rules, you are still counsel of record for purposes of a petition for rehearing en banc and a petition to the U.S. Supreme Court. Take a look at Local Circuit Rule 101 for your obligations with regards to filing either of these motions. Finally, the last key to effective communication with your client is actually communicating with your client. Answer the phone when they call and talk to them. When they write to you about their case, write them back and let them know what's going on. You will be surprised how much they appreciate the communication and your service. If you've practiced law for any period of time, you've likely dealt with a difficult client. And if you're going to accept cases under the CJA panel practice, you might likely deal with one again. It is just part of the CJA process that there are not only clients that are easy to deal with, but those that are difficult to deal with. But there are several things that you can do to make your representation of them easier and make their life easier as well. One of the primary points of friction between you and a difficult client usually is the issues that you are going to raise on appeal. Again, effective communication can dissolve this issue between you and the client. You not only need to provide them with the issues that you think you want to raise on appeal, but you also need to listen to them and listen to the issues that they want to raise. What we do here at the Federal Public Defender's Office is that we invite the client to contact us and communicate with us what issues they would like raised on appeal. Now, with a difficult client, this can be somewhat burdensome because they usually have a lot of issues that you would not want to raise on appeal or you simply can't raise on appeal. In that case, it's important that you not only go over those issues with the client, but inform them as to why you cannot raise those issues on appeal. If you still cannot agree and you're just at loggerheads with regards to those issues, then the next step would be to go ahead and communicate with the court. File a motion with the court to allow the defendant to file a pro se supplemental brief. That way, the defendant can raise their issues the way that they want them raised, and you can still represent them as attorney of record. Finally, in the event that the court does not allow that, or that the defendant doesn't want to do that, at least have the defendant write to you a letter explaining the issues that they want raised, so that way there's some preservation of the issues that you can put into the file. Unlike in private practice, it's not easy to be able to withdraw from a case when you're CJA appointed. You should make every effort necessary to get along with your client, to effectively communicate with your client, and to not withdraw from the case unless you're ethically bound to do so. But please keep in mind the client's perspective. Although the client may seem to be difficult, please keep in mind that not only are they serving a prison sentence, most likely, but it could in fact be a very lengthy prison sentence, and that obviously can affect their well-being. Please also keep in mind that you might not be the first attorney that was involved in this case. They may have had different counsel in the court below, and they may feel like they weren't effectively represented in the court below. Please keep these things in mind as you're representing these clients. I know that it may be hard to deal with these difficult clients, but you should do everything in your power not to withdraw from the case, unless you're ethically bound to do so. Please keep in mind that these clients have gone through quite a bit. They're probably under enormous pressure, they're incarcerated, they might be incarcerated for a lengthy amount of time, and they might have dealt with counsel that they didn't get along with in the court below. You may be the counsel that follows up the counsel that they believe just didn't do that good of a job. So you need to keep these factors in mind as you're dealing with the clients. And finally, and it may just seem like a broken record, but I think it's true, the way that you handle a difficult client is to effectively communicate with them. The more you communicate with them, the more they're going to feel involved in the process, and the more they're going to understand what's going on. And in that way, they will become a much less difficult client.